Good afternoon, everyone. Welcome to another one of our lunchtime seminars organized jointly by the IUA and the AAA. Our topic today is Recoveries with the subtitle, Are You Missing Out? And the person who will enlighten us is John Thompson of RHL Liverpool, who has been a fellow of the Association of Average Adjusters since 2022. We adjusters always like to tell a little story about how we ended up in a profession that hardly anyone knows. John told me he was introduced to average adjusting whilst playing rugby at university. That was Cardiff University, where he earned a bachelor's degree in marine geography and a master's in marine policy, correct? With a focus on marine insurance. I would like to thank the IUA for the perfect organization, as always. I would like to thank everyone here for attending the seminar, and of course, all the ones dialing in from all over the world. And of course, thanks to John for doing the seminar. John, good luck with it, and the floor is yours.
Thank you. Well, good afternoon, everyone. I will crack straight on. So this seminar is not really going to look at questions of fault, as in who's to blame when there's been an accident or a damage. Instead, I'm going to look at sort of and try and talk to you about what happens when a recovery payment is actually made by the party at fault, and how that recovery then gets shared out between the different parties who are concerned. A couple of sort of common examples of this sort of when this may happen includes when one ship hits another and there's a third party liability from one to the other, when a repair is fault or negligence has led to damages occurring to a ship, or perhaps when there's been damage to cargo caused by some fault of ship, or vice versa, cargo has actually caused damage to the ship. When this happens, it's necessary to consider how such a recovery might be divided and credited between the concerned parties. And in doing this today, we'll sort of try and walk you through the allocation of those recovery funds between the assured and the insurer, including looking briefly at the statutory positions, including the Marine Insurance Act, and looking at how recoveries might be dealt with at common law. The provisions for recoveries that are found in different types of policies, such as the ITC clauses, the American Institute clauses, and the Dutch whole form, as well as touching on the Nordic plan and the ABS conditions. I will also briefly look at the apportionment of recoveries in GA, PA, collisions, and loss of hire. As well as that, I'll touch on costs and how they may be dealt with. So to start with, I thought I'd just sort of mention the very early sort of non-marine law case of Castellane versus Preston. This was a case where it was recognised that insurers should be given some sort of subrogated rights to any loss recovered against. The case found that the right of subrogation is a necessary incident of a contract of indemnity, and it operates on every right and remedy by which the loss insured against can or has been diminished. So when do these sort of these subrogated rights arise? In practice, I think, as most of you'll probably know, insurers tend to take quite an active role in assisting the assured in recovery actions from quite an early stage in these sort of incidents. Yet, certainly in English law, that does not necessarily mean they have subrogated rights at that point in time. In English law, the doctrine of subrogation only applies when the insurer has paid a claim. And it's only when the principle of indemnity has operated that an insurer gains the right to be credited with some part of the recovery. Moving to the Insurance Act, which gives a little bit of guidance for subrogation, it's first worth looking at section 63 of the Insurance Act, where it says that the insurer is entitled to take over the interest of the assured in whatever may remain of the subject matter insured and all proprietary rights incidental thereto. Section 79 then goes on to specify that it is only when a total loss is paid that the insurer becomes entitled to take over the proprietary rights of the assured and is subrogated to all of his rights and remedies. Section 79.2 then moves on to talk about what happens when a partial loss happens. And in that case, it's only when the insurer is only entitled to receive benefit of the recovery against items on which he's paid when he has actually paid the claim, not before. So how exactly does this work, and what happens when the insurer pays for the assured in full for their actual loss? In this scenario, an insurer may expect to receive proceeds of the recovery up to the amount of claim that has actually been paid. If the recovery exceeds the claim, then the assured receives the difference. A good example of this is found in the case of Yorkshire Insurance Co versus Nisbet Shipping Company Limited. In this case, there was a Canadian naval vessel that was in collision with the ship. I'll call it our ship for the example here. And following this collision, the insurers paid for a total loss of the ship in the amount of 72,000. The assured recovered from the Canadian government at some time later for the agreed value of the ship at the date of the collision, and this was just slightly more than the insured value. This recovery was paid in Canadian dollars. But when these Canadian dollars were converted into sterling, because of the way the sterling had devalued, a significantly greater amount was actually realised, to the tune of around 127,000. The insurers argued that they were entitled to recover the full amount claimed, or full amount received by the assured. However, in this case, the court actually held that the underwriters were only entitled to recover the amount they'd actually paid to the assured. So what am I telling you is, in practical terms, we do see from time to time where exchange rates do have an impact on cases. For example, fairly recently, I've had one case where AED dirhams were exchanged to US dollars on a one-to-one basis, which gave quite a beneficial recovery to the assured in that case, and we then had to divvy up between the owners and the insurers, with the owners getting the balance in excess of the actual recovery. So it doesn't happen that often, but it's something to be aware of. Next, what happens when the insurer does not pay the assured in full for their total loss? The question here is, I suppose, it comes down to what happens with the policy terms and conditions. But in absence of such, it's necessary to consider the difference between valued and valued policies and the point of impact where the vessel or property is deliberately underinsured. So, as the name suggests, a value policy is the type of policy where the item insured is for a certain value, and depending on the type of claim, any recovery by the insurers may be up to this specific amount of valuation. I would say that we generally do see valued policies in most cases. I think there's very rarely, occasionally, cargo policies we see with the sort of more open, unvalued still, but I think it's very rare. In valued policies, in the sort of in those cases, in accordance with Section 81 of the Insurance Act, the assured is deemed to be insuring any difference between the uninsured balance and claims that are insured on the policy in the ratio that the value bears to the agreed value or the subject matter insured. This is well illustrated by a case called the Commonwealth, which was a case of a vessel called the Welsh Girl, who was insured for about £1,000 on a hull and machinery policy. And when she was run down, I should say, in that policy, the agreed value was actually stated to be 1,350. She was run down by a steamship in fog, and a total loss was duly settled by the hull insurers. The steamship's owners, the ones who'd run the Welsh Girl down, paid £1,000 into the court, and a dispute then arose as to who should actually receive the benefit of this amount. Should this be split between the owners and the insurers, or should the insurers receive the full amount? The insurers contended that they should receive the entire £1,000, yet the owners said we should receive 3/50ths of 1,350. The owner's claim was upheld, and on that basis, the insurer could only recover a proportional amount, and the assured got a proportional amount themselves. Sorry, I've gone too far. The use of the apportionment approach has also appeared, whilst it sort of appears in the non-marine, in marine cases to be fairly well settled following that sort of Commonwealth provision. In the non-marine cases, it's slightly different. Fairly recently, I say recently, a top-down approach has been adopted in two fairly key non-marine cases. The first is Napier v Hunter, and the second is the Kuwait Airways Corporation versus Kuwait Insurance. They took the top-down principle to mean that the first layer, essentially, of the loss got the recovery first. So to talk you through the Kuwait Airways Corporation versus Kuwait Insurance case, this was a case where there was the loss of passenger aircraft and spare parts, followed the Iraqi invasion of Kuwait in 1990. Kuwait Airways lost 15 aircraft that were flown out of the country to Iraq, as well as a number of ground stores. The insured value of the losses were 692 million. However, the policy that was in place at the time had a ground limit of 300 million. This limited KAC's recovery to that amount. In due course, 8 of the aircraft were recovered from the Iraqi side. These were valued at 395 million. And the question arose was how that recovery should be divvied out. Should some of it go to the insurers, or should it all go to the owners in first instance? The court found in this non-marine case that the top-down approach was to be set, and the assured got the benefit to start off with. The courts did note, though, that this was a very different approach to how recoveries are dealt with in marine policies. So, moving on to common marine policies that we see for recoveries, we have the ITC hull clauses 83 and 95. As well as the voyage clauses, standard Dutch hull form. They all give sort of a priority to, they have a similar word into this clause 12.3, and they all give priority to the insurer in respect of the principal proceeds of recovery, where the policy is subject to deductible. Essentially, the insurers get the first bite of any recovery in respect of the claim that they've paid, and the assured will then get anything that's left, if anything. These clauses also provide at 12.4 how interest is dealt with, but I'll come on to that shortly. To give you an example, say you have a claim for 100,000. This is paid by the insurers after application of a 25,000 deductible, leaving a net claim to the assured of 75,000. There's then a recovery from the party at fault for 80,000. In accordance with 12.3, the recovery is credited to the insurers up to the amount that they paid, so 75,000, with the balance falling to the assured. Different policies have different clauses and different approaches, and certainly whilst you get the first bite approach under the ITC clauses, under the American Institute hull clauses, the IHC 2003, ABS clauses, and the Nordic plan, different approaches is taken, where the recovery is split on more of a balanced approach depending on what people have lost, similar to how it was with the Commonwealth. For the American hull clauses, there's no actual specific provision as to how the recovery should be approached, so it's left to the law, like it was with the Commonwealth that we discussed earlier. Yet some of the clauses, such as the international hull clauses at section 49, do state how recoveries are to be approached. The Nordic plan also has a similar clause at 513, where it states quite clearly the recoveries are to be apportioned between the insurer and the assured in proportion to the loss that they have covered. In normal sort of situations where recoveries to the assured are subject to a deductible, this sort of means the assured will participate in any recovery from a third party in the proportion that the deductible bears. Possibly best described with an example. So using the same claim figures as we used before, you've got a gross claim of 100,000, which after deductible gives you a net claim of 75,000. Yet for the actual recovery, the way it is dealt with, the insurer under the American Institute hull clauses would get 75/100ths of the recovery, i.e. 60,000, and the assured would get 25/100ths. And the similar sort of process works with the IHC and Nordic plan. Moving on now to recovery of interest. Interest can be a key component of any recovery, and this was sort of expounded in the case of H. Cousins versus D&C carriers. This was a case where a cargo of clothes disappeared in transit, and insurers paid out for the loss of the clothing before taking an action against the transit company. Settlement was made up to the value of the goods lost, but this did not include interest. The courts agreed that interest should be included and that the assured were entitled to recover this interest from the date that they were out of pocket up until the point that the insurers had paid the claim. The insurers were then able to get the interest accruing after that point. In the ITC 83 and 95 clauses, interest comprised in recoveries is apportioned between the assured and the insurers, taking into account the original amounts paid by the insurers and dates that they were paid by different parties. Importantly, this is quite a distinction in the way that the recovery approach is dealt with from 12.3. It's also noted that insurers can actually recover more than they paid out for once interest is accounted for. Interest under the Nordic plan is dealt with in much the same manner as recovery, based on the relative interests of the insurer and the assured. However, it's stipulated that where the claim for the recovery, including interest, is more than the net amount paid to the assured, the balance accrues to the assured. So to give you an example, based on the ITC conditions, you have a PA claim of, say, $1,000, when after 6 months, payment on account is made for $400,000 by hull insurers with a $100,000 deductible. The remainder of the PA claim is then settled 6 months later, and a recovery is subsequently obtained 2 years after the initial damage, plus interest calculated at 5% per annum. So how do we approach this? As you can see, division of the recovery between the assured, the hull insurers get the first bite at the recovery of up to 900,000, and the owners get that balance that the hull insurers don't take with the first bite. That's much what we've talked about already. So the interest, and I know the figures might be slightly out on this, that when we look to divide the interest, we're looking at exactly when parties are out of pocket. So in this case, for the first 0 to 6 months, it is the assured who are fully out of pocket for that period. 6 to 12 months, you've got to split the interest between the parties who are out of pocket, i.e. for the payment on account, the underwriters get credit for that period and the owners get credit for the rest. After the actual claim is paid, after 12 months, the interest then translates to the insurers for as much as they have an interest for. That's very much sort of set out for sort of a simplistic sort of way of looking at it. In reality, we have to quite carefully consider the dates that people have paid, what amounts have been paid on different amounts, and you can get quite often get some interesting situations where exchange rates have an impact at different times as well. And it's always that's one of the big questions that we always have to ask when we're preparing recovery adjustments. So moving now to the apportionment of recoveries for GA interest, and what happens when there is a recovery of GA, including GA interest. The York Antwerp Rules, Rule 21, provides that interest is allowed in GA at 7% per annum, and that can form part of the GA claim. So in order to allow interest to accrue properly, you have to give credit for that 7% interest according to where it attaches. For GA interest, it attaches to the expense from the date the expense was paid by the assured, and not according to when the claim was paid by the actual owners. Again, perhaps best dealt with an example. In this case, say the loaded vessel is on a collision and is obliged to put into a port of refuge for repairs. The ship owner finances all of the expenses incurred, and the GA adjustment is then prepared and settled a year after by the insurers as follows. So you have ship's portion of GA at 120,000, GA interest thereon at 7% of 8,400, a deductible of 50,000, which leaves you with a net claim to the assured of 78,400, assuming ITC 83 clauses. A recovery is then made from the other vessel for the GA expenditure of 120,000 and interest of 24,000 based on 2 years at 10% per annum. So this is where whilst the recovery of the actual claim amounts is dealt with in the usual way in accordance with ITC 12.3, the way interest needs to be dealt with is slightly different. when you have GA. Interest of the first 12k for that first year, based on the 10% has to be divided, with the division of interest going to 7% going to the insurers for the GA claim that they paid out. The assured then receives the balance. After that first year, when everybody has already paid their claim and there's no sort of GA interest continuing to accrue, all of the interest then sort of reverts back to the normal practice, normal way of being split between the assured and the insurer. Worth noting, with the division of recoveries in GA for different parties, is it always beneficial when you have a collision to make a joint recovery where GA is involved? Is that always going to give the best result for both cargo and for ship? To give you, it's worth sort of, the best way to describe this is through a couple of law cases where this came about. The Marpessa was a case where it's indicated that cargo interests have no right of GA claim against the other vessel, as their GA claim is solely between them and their carrying ship as part of a carriage of goods between ship and cargo. Instead, owners of the carrying vessel would have to include cargo's proportion of GA as part of their claim against the other vessel, and then any recovery thereon has to be apportioned. This case was slightly overruled in the case of Morrison versus Greystoke Castle, the Cheadale. This was where it established that cargo, once they'd paid the GA contribution, had their own right to recover directly against the other vessel for damages in their own name. This sort of seems to be quite clear, I hope, and it gives two different routes for people to recover their GA interest, or for cargo to recover the GA element from the other ship. However, where it becomes slightly trickier is if you lump everything together, ship and cargo together, and that, say, for example, the other ship limits liability, there's difficulties with cross liabilities, which means that when things get broken back out on our side as to how the claims might sort of been divided up, cargo may not actually get any recovery. Similarly, if the way the single liability settlement works, if the single liability settlement is actually in favour of the other vessel, i.e. our vessel is paying the other vessel a full amount, there is actually no recovery to our side. So it leads to some quite tricky questions as to how cargo would actually receive their recovery at that point. Whereas even if there's a even if the other vessel did limit their liability and cargo had pursued them in their own right, they would still have a right of claim against the other vessel for a certain amount. I think in our experience, cargo are quite often reluctant to get involved in the initial sort of collision negotiations, as they probably quite rightly fear that they have to pay costs of determining liability, etc. So I think the takeaway from this is really it's always something to think about whenever you have these sort of cases. Is it going to be in the best interest of cargo to go on their own way in pursuing a claim against the other ship, or are they better off lumping in everything with the ship in trying to make their recovery? Next, sort of briefly touch on recoveries of GA sacrifice. As can be seen in the Insurance Act, section 64.4, if a cargo insurer pays a cargo claim for a partial loss caused by sacrifice, he's subrogated to all rights and remedies of the assured, i.e. he'll recover ship's proportion of the sacrifice then paid. However, if you have a case where a P&I club may pay a cargo claim on behalf of the ship owners to cargo insurers, and then there is a subsequent recovery from somebody else, the P&I club does not necessarily have an automatic right to be subrogated to cargo insurers' rights in GA, or subrogated in the same way of cargo insurers' rights. And to this end, we'll quite often see P&I clubs requesting an assignment of rights in these sorts of cases. Moving on, collision recoveries. This is probably a topic in its own right for somebody to talk about at another time. But I think it's worth just highlighting here the principle of cross liabilities, which ensures claims and recoveries are properly allocated between the correct heads of claim. So in a single liability settlement between two colliding vessels, each vessel is liable for its share of the total amount of losses suffered according to the degrees of blame for fault. From a vessel to vessel point of view, this is sort of fairly simple and everybody's quite happy. But where the difficulties sort of arise are where how those sort of single liability claims then get broken down, especially if you've got, say, one particular element of claim has really made the vessel's single liability sort of claim much higher than the other. How do those recoveries or notional recoveries then get fairly settled? Insurers will, of course, want to receive their subrogated rights to any recovery, but what if the I suppose, as I'm trying to say, what happens if the recovery is primarily being made on basis of a non-insured loss by the owners? This point came up in the Ballan-Craig London SS versus Grampian Shipping Company in 1890, where there wasn't really a clause that dealt with cross liabilities at the time. In that case, there was no recovery under the clause that was drafted because repeating myself there, the insured's own claim for demurrage actually increased the amount that was to the benefit of single liability, yet they didn't see any recovery or any benefit accruing to them as a result of the single liability settlement. This was deemed to be unfair, and the cross liabilities wording was introduced. The cross liabilities clause therefore sort of treats each vessel as being liable to the other for its degree of fault, but opens up the calculations for losses and recoveries to be correctly attributed to the people who are actually contributed or whose claims are key to that recovery. The loss of hire recoveries, these, from a general point of view, these generally follow the point that I was making earlier with the Commonwealth and the sort of dividing between different losses as called, or different interests to the loss. What is worth just noting, though, is clause 16.16 of the Nordic Plan that specifies the loss of hire insurer is subrogated to compensation otherwise gained under the vessel's hull and machinery policy for loss of time and operating costs during the removal to repair yard or in a GA situation where allowances for such costs may be made. I.e., so you've got hull and machinery claim, loss of hire claim, and under the hull and machinery claim, you've got sort of wages and maintenance and various other operating costs that form a good part of that hull and machinery claim. Yet the loss of hire insurers have already paid a claim for these sort of operating type expenses, as you might see as part of the loss of hire. Question is, well, the way the Nordic Plan deals with it, it gives proper credit or proper subrogated rights to the loss of hire insurers to recover benefit in respect to those amounts allowed under other policies. This position is not quite so clear in English law, and generally the view is taken that hire has to be divisible, or hire is divisible, sorry, and the wages are part of the rate of hire. So there is a need for them to be credited back to the loss of hire, basically to try and put yourself back in that position where you avoid that double indemnity to the assured. Moving on to the treatment of costs of recovery. Generally, each party concerned in the recovery should bear the costs of making the recovery. I think that's a fairly straightforward concept, I think. The ITC 83 and 95 clauses are generally sort of fairly silent on how these costs should be dealt with, whereas the Nordic Plan and the International Hull Clauses 2003 do make provisions for how costs should actually be dealt with. It's very well sort of summarised, I think, in the Nordic Plan with the quote that's on the screen at the moment. So that's fairly straightforward for most recoveries. As I was saying, the IHC specifically provides who pays for costs of recoveries at 49.2. It then goes on to say that where some sort of legal action has been taken by the assured to avoid an actual hull and machinery claim arising, and that's successful and it avoids any claim on the hull insurers will agree to pay certain amounts of costs in avoiding that claim, or certain costs to help with that recovery without application of the deductible. I suspect, but I don't know, I suspect that probably happens without this wording, but it's probably on a case-to-case basis. Worth also mentioning are the association's rules for collision costs. This is not strictly a recovery of costs from a third party, but Rule 8 actually deals with how costs are allocated and charged properly to different heads of claim, even when paid by different parties. Without this rule, it'd be quite difficult to properly allocate the costs to the parties concerned. To give you an example, whilst costs associated with making a recovery against an owned vessel have to be apportioned and debited against the heads of claim being made, costs incurred for actually defending against third-party claims have to be allocated as a specific claim on the policy. So it's a very different way of approaching different types of costs and making sure they're properly credited and debited to the right parties. From a sort of quite practical point of view, it's worth noting that where you do have these sort of multiple heads of claims and costs being paid by different parties, sometimes the only way to really get to the final result as to who should really have the right credits and debits is to draw up a statement of recovery and to do a financial balance showing everything that people are owed and due to pay. So slowly, or finally getting towards the end now, and I thought I'd just mention what happens if adequate steps are not taken to protect a recovery position. We do sort of get questions occasionally about what sanctions might arise if there's a failure to take adequate steps to protect a recovery position. And this can be quite difficult. I mean, for example, you have a ship owner who has quite a large fleet, and each vessel in that fleet has multiple auxiliary engines taken from the same engine manufacturer, and the owner has to maintain quite a close working relationship with this engine manufacturer. You can see sometimes there may be a reluctance to try and pursue them for a recovery because they want to maintain that sort of amicable working sort of arrangement between them. This can cause some difficulties, as you can probably imagine. There's not a great deal of law cases on this, and but perhaps the one that is worth mentioning is the case of the Vaso, which is from 1993. In that, the cargo insurers argued that there was a failure to comply with a specific provision for protecting their interests in a recovery, and that amounted to a breach of a promissory warranty. The courts rejected this, and the general view that appears from this and from other cases, as well as Arnold and Marine Insurance, is that in English law at least, and in the absence of any sort of other policy provisions, get my caveats in there, seems to be that there is certainly an obligation on the assured to protect the insurer's position, and subrogated rights that are lost due to the inaction of the assured may give the insurer rights to counterclaim for damages to the extent of the benefits that have been lost. In practice, I think it's probably quite difficult to say what the final results would be. Certainly under Nordic Plan, there are provisions that do give right to what the sort of sanctions would be. Moving on to where, and certainly in the ISC, there is an obligation that does require that the assured do take reasonable steps. The ITC 83 and 95 clauses do not oblige the assured to, or there's no specific provisions obliging the insured to protect rights. Although I think, despite there being no sort of written obligation, leading textbooks do tend to suggest that there is still a duty, certainly at least not to actively prejudice any rights of subrogation that the insurers may have. And I think it's also suggested that any breach of this duty may open the door to damages to be sought, to allow damages to be sought by the insurers. Although again, I think there's very little in way of law case or practice to support how this might actually be approached. So that's us coming towards the end of the seminar now. As mentioned, sort of just to briefly recap what we've covered. In English law, the doctrine of subrogation applies when the insurer has paid a claim. Insurers are generally only entitled to recover up to the amounts paid plus interest and costs. When a recovery is not for the full amount of the claim, care has to be taken to consider the policy conditions, first bite, or how it should be apportioned over the losses sustained by different parties. Interest comprised in recoveries has to be apportioned between the assured and the insurers, taking into account the original amounts paid by the insurers and dates they were paid, with particular care taken where GA interest is involved. And each concerned party should also generally bear the costs relating to their own recovery of claim, although again, with collisions, we do see slight variations here. And I guess here's a final plug for where we actually fit into all of this. We tend to fit in where we're asked to prepare a statement and a calculation of the division of recoveries between different claims, PAs, GAs, collisions, loss of hire, and that generally includes the first bit, the actual recovery of damages and recovery of loss, the recovery of interest, how that is divided, as well as dealing and dividing up the costs themselves. I think that is about me. So any questions from anybody?
Microphone for the
Robin Eggersbury, Mediterranean Average Adjusters. That's very well expressed. If I listened to the whole thing right the way through, it's most unusual to keep awake the whole time. It's fantastic. You've done very well. I presume that this will be available as well. Coming to the very last point, what would you do with the adjusters' charges? Would you apportion those according to the recovery? Or you would do as I do, and have done for some years, because it wasn't done originally when I started in the business, to charge the fees in full to the underwriters that are receiving the recovery, on the basis that the assured has recovered in full. And the only reason that the adjustment is prepared to deal with the recovery is to distribute the parts to, the funds to underwriters. So in other words, there was no need, as far as the assured is concerned, to have an adjustment prepared.
I think it's a good question. I think certainly from the cases that I've seen, and I've sort of recently been involved in one, in that particular case, there was a PA recovery, there was a loss of use recovery, and there was quite an extensive recovery for items that were not insured against. And there was it was a collision case. We also had to deal with the claim on the collision clause. In that case, we felt the most reasonable approach was to divvy up the fees across the different heads of recovery and the different heads of claim. That was felt to be the fairest way of approaching it. There may be, as in the example you gave, there may well be different alternatives for different cases. I don't think it's one where you can say there's any particular correct fixed practice on this.
Just following on, John, on that same topic, do you have to get instructions from all the heads of claim to do this?
In my experience, we've quite regularly been appointed by owners directly to do this. At other times, insurance brokers will ask us to deal with it, and sometimes insurers themselves, who are aware that there's different heads of claims involved, will actually come to us and say, we'd like you to do this. And obviously it's then a case of just joining the dots and making sure nobody has any particular issues. And touch wood, I don't think anybody's had particular issues, particularly on the really complicated cases where you do have these sort of quite tricky questions.
Richards Hogg, 7 Kings Bench Walk. John, it's a terrific presentation, and I feel like I need to watch the whole thing again. So I very much hope it will be put on YouTube or something like that, but thank you. Just a comment as regards, there's 2 different methods by which cargo can get their recoveries in GA, the Marpessa method and the Greystoke Castle method. It's odd that we've got these 2 different ways of going about it. Just a comment, I wanted to point out how if the cargo are suing the colliding vessel, then they've only got 2 years to do it under Section 193 of the Merchant Shipping Act, which brings in a time bar under the Brussels Convention. So you mentioned you might need to kind of think which way to do it, but just don't think too long. That's my point.
Good point. I hadn't realised that. Thank you.
And the Vasso 1993, it just made me think of the toxic sofas case of 2008, I think, Horwood and Land of Leather, where there was a decision in which there was prejudice of subrogation rights through the entry of a settlement by an insured with a third party, and I think the court did look into the extent to which the insurers were prejudiced, just to put that out there.
Okay, yeah, thank you. No, that's
Thank you very much.
Thank you.
Sorry, but could you please explain that case law whereby there was going between single and cross liabilities? I didn't fully comprehend it. Sorry.
So,
London SS owners.
so yes, so the Marpessa method and the Greystoke method, the Ballan-Craig. Sorry, yeah. So the Ballan-Craig was essentially a case. This was at a time where there wasn't a cross liabilities clause included within the particular policies at that point in time, and this was a case where I think, if I remember rightly, you had a recovery for damages, but the most part of the recovery was made up of loss of use or something similar. And when the single liability settlement was done, there was actually no recovery given to the owners for their, even though it was their loss of use that had really contributed to getting them the single liability settlement. I think that's right. I'm sure I'll be corrected if I'm wrong, but I think that's the basic principle of it. And it was decided it was unfair and that proper credit should be given where they were due. Okay. Stunned to silence.
Any other questions or comments?
Like I say, stunned to silence. I'm happy. Done.
These recoveries are not as complicated as in reality. It is a bit different, and it can become really complicated. We had several cases, I'm sure you had as well. For instance, container ship fires, cargo fires, where the culprit, the bad container is identified fairly soon, and you know that there is one party to blame, and it's definitely not the ship owner. So of course the straightforward scenario would be that everyone, the ship owner and all the other cargo owners, just go against the shipper of that cargo, or the insurer of that cargo. In reality, of course, that doesn't happen. There will be lots of procedures involved, and in the meantime, you have a general average situation, and you have a lot of sacrifice damage, and cargo insurers start settling claims for sacrifice damages directly. P&I clubs might jump in, for instance, the Charters Liability Club. And between all this is the general average scenario. And somehow you have to finish the general average, bearing in mind that there will be a recovery action against a third party that potentially should cover all the losses. In most cases, it's quite difficult to go against the shipper of one particular container of calcium hypochlorite or something like that, and it takes ages. But then once you have a recovery action, you can find out that the general average settlement somehow disturbs the recovery action, because you're asking innocent cargo interests to contribute to expenditure and to sacrifices of other cargo of the ship. And all this has to be considered then in the recovery action. So you have a whole level of redistribution within the whole general average regime, which then has to be again considered in the recovery. And that, I can tell you, makes it very complicated.
Agreed. Especially if there are certain recovery agreements where the GA isn't proper, or sacrifice isn't properly dealt with, which means credits are not properly given to different people.
Okay. Thank you very much, John.
Thank you.
Great seminar. All right, there is a lunch next door.